The matter before the court is Oxford 2360 regarding the Children of Destiny. We are being streamed, so I'm going to, given the nature of the confidentiality, we'll be careful in this case, but we are being streamed live on the web, both for video and audio as an experiment here. And I would ask counsel to identify yourselves by saying your names for the record together with the party you represent, starting with appellant.
Taylor Kilgore. I represent the appellant mother, Destiny H.
AAG Hunter Umphrey for DHHS.
Thank you. Counsel, if you're ready to proceed, we'd be happy to hear your argument.
Thank you. May it please the court. Child protective cases have a primary goal of achieving permanency for children. This goal is delayed each time a parent and their child suffers from ineffective assistance of counsel and prejudicial trial management tactics. By reversing and remanding this case, you will set the standard for thousands of children that will come before Maine's courts in the future and ensure that they won't wait for permanence because of procedures that are inconsistent with constitutional due process protections. The errors in this case by counsel and the trial court are severe. If this court does not reverse this matter, it is a statement from the law court that even these types of egregious errors and deprivations of rights will not be disturbed on appeal. It will endorse judicial acceptance of such poor practices that are so abundantly obvious from the record here. The process must be fundamentally fair. The client must have effective counsel at every stage, or we end up here with a family that is irrevocably broken and a procedure that we cannot have confidence in. This court must seize on the opportunity to ensure that no other families go through what Destiny's family has gone through. I welcome your questions.
We're here on an appeal of both of the 60B and of the actual TPR.
Yes.
And your opening statement focused on the effectiveness of counsel.
Yes.
One of the elements, of course, on that is whether it made a difference. And so even if we agree with you that perhaps the practices of counsel in this case, particularly since no one apparently ever thought they needed to file a witness list, were less than appropriate, how does it make a difference?
It makes a difference, Your Honor, because we can't rely on any part of this process in having produced a just result. We all are here because...
But is that a good enough to meet the test? I mean, we say that it's more than that, isn't it?
It is, but there's such procedures that can happen and such egregious, as we kind of see here, that we can't have confidence in that the result here is reliable. It's part of Strickland. It's part of... the Chronic case talks about how sometimes the outcome is just so unreliable and the counsel is just so ineffective that we can't have any sort of confidence in the result that has come out, and that in itself is the prejudice. We can't be confident that any step of this process provided that fair procedure to Destiny or her family.
And so I turn first to the then appeal of the TPR itself on the record. Sure. Of the TPR. I mean, obviously most of this has been spent on the effectiveness of counsel. Do you concede that as presented, without the additional information that more could have been presented, as presented, the judge's findings can be sustained?
I don't think so, Your Honor, because I don't think that we can rely even on the jeopardy findings in this case, which the court relied on pretty heavily. I think that this entire process from the first part of it, there are no findings all the way back to jeopardy that we can rely on as having having been through this process, this adversarial process that we put all of our confidence in.
Okay, but aren't you still going to whether or not there was effective assistance at each stage? And I'm saying based on the cold record, as we would normally do in reviewing the TPR judgment, putting aside the 60B proceedings. I mean, can we do that? Can we look at the What do we do with that anyway? If we say on the cold record of the TPR, I would affirm because there's sufficient evidence in the record to sustain the judge's findings, and yet now we have this.
I think the trial court even told us that she didn't have sufficient findings. That order states that they don't have any information about the mother's mental health. They don't have anything about all of these reunification services the mother did, and that was because, again, these two issues are so intertwined with one another that I'm not sure that we can pull them apart. That we can't look at the TPR decision without looking at the fact that the mother had...
But she didn't really say we don't have information. She said, I have no evidence that she did what she needed to do, essentially.
Correct, because mother wasn't allowed to present any of that information because her counsel had failed to file a witness and exhibit.
She did present some. I mean, she presented her own testimony. She presented her own testimony that she did some parenting, that she did some, counseling, both with her counselor who testified at least about the beginning of the session, as well as her psychiatrist.
Right, but the court also found the mother not to be credible. If there were additional witnesses that bolstered her testimony, then perhaps the court would have found her credible because other people would have also testified to those same facts.
Okay.
Didn't mother actually interfere with getting further evidence from her mental health counselor by not providing necessary releases to allow her to not engender the opposition from the guardian and from the state?
So effective assistance of counsel requires counsel. It's part of what we do in child protective cases. It's that back and forth with your client and helping them understand why they're being asked to do the things that they're doing. Without effective assistance of counsel at any step in this process, I'm not sure that that was ever explained to Destiny. I think there's an additional issue that the state always had the availability of getting investigatory subpoenas, if I can say that correctly today. And they had other tools available to them other than going through the mother for that information. It wasn't just a failure of the mother, it was a failure of the counsel that she was receiving and the other parties in the process not exercising their ability to go and get those records, as they do pretty normally.
Did the court have the power to tell Mr. Robinson he couldn't enter his appearance?
I don't think so, Your Honor. I don't know of any authority by which the trial court has the ability to deny an entry of appearance.
Can you speak to the 60B process? I mean, essentially what happened was, under MP, the affidavit of the witnesses are required to be filed, and the court essentially in the 60B said you didn't file certain affidavits.
They absolutely did, Your Honor, and I, with all due respect, I think that the court in MP didn't set a reasonable timeline. I was appointed 32 days before I had to submit that 60B6 motion. 32 days inclusive of weekends, inclusive of all of the other things I had to do in other cases. I had to learn that entire file. I had to, which almost didn't exist, I had to ask the court, as is shown in the record, for the rest of the court orders. Learning this entire case and all of the things that existed not in the record. I think what also happened as we litigated the 60B motion, there were all sorts of things not in the record that came out, which is the point of the 60B process. But I think that the requirement that affidavits have to happen in order to bring those witnesses, it should change.
Was there a motion to amend the 60B motion and to add additional affidavits?
There were, and that motion was denied as being untimely. And I think, it's
When was it filed? Can you refresh my recollection?
It was filed on the same day as the 60B hearing.
Isn't that a problem, though?
I don't think it is. The court in In Re MP said that you have to file that 60B motion preferably within 21 days, but promptly. I think in Re MP, I went back and counted the days. There's 104 days between the time of the TPR order and the time that 60B motion was filed in Re MP. Here, the timeline between those two things is 49 days. My motion to amend was filed on day 102 after the termination order. According to In Re MP.
But I mean, the judge that hadn't even seen the motion to amend the 60B, right?
Correct, and we asked that the record stay open to allow her to rule on that motion and to allow us to bring additional witnesses. She denied that. I think that it wasn't an unreasonable timeline. I think that we filed those things as promptly as we possibly could have as the information got to us. We filed a motion to continue because we didn't have even the full record of this case because it didn't exist from prior counsel. I had to get it from the court, and I didn't get it from the court until the day of the motion to continue, which was less than 10 days before this hearing. It creates a situation almost similar to what's discussed as one of the prongs in chronic of how could any attorney be effective under those circumstances? How every single one of the hearings in this case was held when counsel was appointed almost a month or less before the hearing dates. How can any counsel be effective when we're hamstringing them by not providing them with the time that they need to adequately prepare for these hearings? We're setting folks up for failure, especially given the crisis that it is existing currently within MCILS and OCFS. There's not being the time provided to do this job and do it well. That affidavit requirement, I think additionally, Your Honor, is problematic. I can't compel any adverse witness to sign an affidavit. I can certainly subpoena them and get them to come to court and testify. But if they're an adverse witness, they have no reason to return my phone call. They certainly have no reason to sign a voluntary affidavit. I mean, that was part of the problem here is one of the attorneys that served Destiny said he would file an affidavit and then didn't follow through with that. We couldn't compel that. I could serve him with a subpoena and make him testify at the 60B6 hearing, which we did. And the court was kind enough to let us do that, but didn't let us do that with other witnesses that we had asked to be able to bring who were completely relevant. We just didn't have the ability to compel these folks to sign affidavits. Thank you.
Thank you.
Good morning, Chief Justice Stanfill. May it please the court. This case is about two children, one born in 2014, the other in 2021. In September of 21, someone hurt the baby. A doctor who saw him in the ER said that he was limp and near death. He had a fractured clavicle and a brain bleed. Two people had recently been with him, the appellant and a person named Jason, who was her boyfriend at that time. Jason texted the appellant that he thought he could get the baby to stop crying by, quote, doing it my way, and it backfired. The older sibling said he saw Jason hand the baby to the mother and apologize for hurting him. The district court removed the children from the mother's custody, and this case began. The whole point of these cases is for parents who abused or neglected their children to work collaboratively with DHHS to try and rehabilitate themselves and be reunified with their children. In this case, the appellant refused to participate in that process. The court in the jeopardy order directed her to sign releases, but she did not. She chose instead to leave the department and the guardian ad litem in the dark. Crucially, at the termination hearing in December of 2022, the mother testified that she still does not know what happened to the baby and that she does not believe the injuries were inflicted. That's the heart of this matter. That's the heart of her unfitness. That's the heart of the lack of prejudice that's been demonstrated, which is the reason the ineffective assistance of counsel claims against those 4 lawyers failed. By the time she testified in December of 2022 at the TPR hearing, she had fired 3 court-appointed attorneys and hired a 4th attorney to represent her at that hearing. The attorney who represented her at that hearing was the attorney she chose to hire. In March of 2023, she moved for relief from judgment, alleging ineffective assistance of counsel. She has not carried her burden of proving those allegations up. We're asking this court respectfully to uphold the judgments on appeal, and I welcome your questions.
Do you agree? You talked about the working collaboratively with the department, but whether or not a parent collaborates with the department doesn't make them unfit.
Well, it could.
I understand there may be other issues.
I look to Section 4041 of Title 22 as the touchstone of the mutual responsibilities that parents and DHHS both bear. And the responsibility is on both sides to meet halfway toward that goal, which is always the primary goal, unless and until the court says otherwise, of rehabilitation and reunification.
Right. The parent's obligation has the obligation to undergo rehabilitation and reunification. If the parent chooses to do that without working with the department, my point is a failure, let me phrase it differently, a failure to cooperate with a caseworker, a failure to talk to the caseworker, a failure to cooperate in any way with the department is not in and of itself unfitness. It may indicate a lack of reunification, but the question is whether the parent did the services, did the things that were necessary. And I understand there may be evidence in this case that she didn't, but everybody kept focusing on whether she signed the releases or talked to the department. And it's the failure to sign releases does not make her an unfit parent, does it?
Not on its own.
And the failure to talk to the department doesn't make her an unfit parent.
She's unfit because years into the case, she's still professing to be bewildered about what happened to her child.
That's a different issue, isn't it?
That is a different issue.
Okay.
In terms of speaking about why she has failed to demonstrate any prejudice, let's look at Dr. Barter's evaluation, not admitted in evidence, but proffered as part of the late 11th hour motion filed the morning of the motion hearing. Dr. Barter himself said that it appears one difficulty for this individual, I'm on page 13 of his diagnostic eval, is that she's been too focused on DHHS to the possible detriment of her own work at alleviating jeopardy. This is a witness who the appellant now says she's prejudiced by the fact that he didn't testify. On the contrary, I would suggest that his testimony, if it had been admitted, it rhymes with Judge Ham Thompson's finding that she is unfit, because years after this child was grievously injured, she is still professing to be unable to explain what happened, even though Jason texted her what happened. And that's the nature of her unfitness. If you look at this court's Kafia M decision from the late 90s, we have good language on how we analyze a fact pattern like this, where a child is grievously injured in a parent's care and the parent fails to account for what happened. It doesn't bode well for the parent's future ability to protect that child.
But again, the focus is there, and the point there would be that this parent may not recognize that the significance of the injury, or that this was an inflicted injury, and therefore may not be able to protect. It's not whether the parent is cooperating with the department on that.
That's right. The cooperation is a sideline issue in the sense that it's theoretically possible to imagine a parent who says, I am closing myself off, I'm going to privately do the work, and I'm going to come back at TPR, no one will know what work I did, and I'll explain it then and demonstrate what I've been up to. On this record, this appellant never did that. We have an affidavit also from the late filing from her counselor who said she made, quote, moderate progress. This court's case law says marginal progress and a simple desire to remain the parent is not enough to alleviate jeopardy. It wasn't enough here. She did not alleviate jeopardy in time. These children are now desperate for permanency, so we're asking this court to deliver them that
Can we go back to the jeopardy order in this case?
Yes.
I understand there was no 60B filed directly after the jeopardy, which I'm going to put that aside for the moment. But what we have here is again, at the 11th hour, a jeopardy order with a cease reunification, although it did an aggravating factor in a cease reunification, although it had some provision for some reunification services, right?
That's right.
And that cut off visitation that had been happening with her older child, correct?
That's correct. And we have an interest.
And we have an agreement put on the record where the attorney puts it on the record and says, yep, we're agreeing to this. Well, she doesn't really agree, but she understands she needs to do it. And nobody asks her. She doesn't speak up on the record. She was present. There was an extended colloquy, and he said she was not happy about the circumstances that she was in, but he reiterated multiple times that this was an agreement. And that they were agreeing to a cease reunification and an aggravating factor when there was not really direct evidence that she was the one who had hurt this child?
We know from the motion hearing that occurred and the jeopardy lawyer's testimony that he knew privately from one-on-one attorney-client privileged communications that she was desperate to avoid a hearing. A detective was calling her repeatedly. Well,
that's what he says. She says she wasn't, and in fact, the guardian, as I recall, testified that understood that it was going to be. Everybody thought it was going to be a hearing right up until the end.
Judge Ham-Thompson, as the fact finder, had a job to do of making sense of the maelstrom of the competing claims. You're right. The mother testified to a very different set of facts than her lawyer testified to.
But isn't the problem here that whether it's the attorney representing her at the Jeopardy hearing or the different attorney representing her at the TPR hearing, whether or not they secretly were hoping for a good result and a settlement and all that, there's not even witness lists filed or anything else filed. And they did have witnesses. I mean, she had a counselor and a psychiatrist, right?
She did. And the heart of the matter is the prejudice prong of ineffective assistance of counsel. It's a formula. You need to establish deficient representation and prejudice resulting from that. And she's failed to demonstrate that prejudice. Those witnesses' testimony wouldn't have materially changed the outcome here on this
And we
record.
know that because with regard to the psychiatrist?
With regard to the psychiatrist, I'm not certain we do have an affidavit still. With regard to the counselor, we have one saying she made moderate progress. With regard to the psychologist who did the diagnostic eval, we have a 14-page evaluation that includes the quote I read earlier.
You're talking about the code?
From Dr. Barter.
From Dr. Barter.
And which includes his observation that she has let the fixation on her issues with DHHS distract her.
What do we do with Attorney Kilgore's exhortation, which I happen to agree with, that part of the whole role of counsel, of a parent's counsel, is counseling their client, sometimes successfully, sometimes not. We all understand that, okay? But counseling them on the consequences and the different options and everything else.
I agree, 100%. That's the hardest part of being a lawyer. I've been in private practice, I've been a public servant. That's the hardest part of being a lawyer. The bottom line, though, is that it's not the lawyer who has a responsibility to protect the client's children from abuse or neglect. We know from the legislature in establishing this entire statutory framework that the right to family integrity is limited by children's right to be free of abuse and neglect. We know from our state constitution that people in Maine, including children, have a right to pursue and obtain safety. One of these two children was grievously harmed in the mother's care. Years later, despite all the evidence to the contrary, she insists she doesn't know what happened. It doesn't augur well for her.
Well, is there evidence to the contrary that it was her that injured this child? Or to the contrary, do you mean that the guy she was with at the time?
We don't have video of what happened. It appears on this record, I would submit, most likely that it was the boyfriend and not her. He texted her something that would appear to be
I just wanted to clarify that.
She agreed to jeopardy orders that, to a jeopardy order that included a finding that Spurwink's medical doctor had done an evaluation, determined they were inflicted.
And you think that means she engaged in whatever the word is, the heinous and abhorrent behavior that leads to an aggravating factor?
Well, according to the jeopardy order she agreed to, the answer to that question would be yes.
And that counsel agreed to, that we have to wonder whether that was appropriate, right?
He explained what sounded like a very difficult attorney-client representation that he took on as a public service, taking a court appointment that too few attorneys are willing to take on. He was dealing with a client who told him, a detective is calling me, I'm worried about criminal liability, I don't want to have a hearing where I'm potentially pleading the fifth. I will agree to anything, is what he said. She told him. He hammered out an agreement with the AAG, maintaining his poker face about the hand he actually was holding. He hammered out an agreement that met the criteria she was looking for, in the sense that it still afforded her a pathway back to reunification if she was willing to do the work. He secured that for her. She didn't go down that road that the jeopardy order set out for her. And that's unfortunate, but it's the reality. At this point in time, these children are now desperate for permanency. She did not attain parental fitness in a time frame reasonably calculated to meet their needs. I thank you.
Thank you. Ms. Kilgore, you reserve some time for rebuttal.
I did. Your Honor, I would just make a couple of points to things that Attorney Umphrey said. Destiny didn't fire any of her counsel. If not jeopardy counsel, he withdrew because he had a perceived conflict. That was his choice because he knew that Destiny didn't agree with the jeopardy order and that she didn't understand.
Perceived conflict with her, you mean?
Correct.
Yeah.
That was his decision. That was not her firing him. Additionally, interim counsel between Jeopardy counsel and TPR counsel, she wasn't fired either. The court knew when they relieved Jeopardy counsel that she had stated that she was going to hire her own attorney. They then appointed interim counsel. That wasn't her firing her attorney, that was her getting her chosen counsel that she wanted. I would also submit, Your Honor, that we don't know the impact of Dr. Barter or other witnesses' testimony at all, because they weren't allowed to testify in any way at any of these. And if it was going to be so helpful to the department, why did the department fight and not want him to testify? Why did we keep him out? Your Honor, I would just, you mentioned that the Jeopardy order stopped visits with the older child. She was also having visits with the younger child. All of those visits stopped at the Jeopardy order by her supposed agreement. I think either Attorney Umphrey or Your Honor said that there was a colloquy at Jeopardy. Not with Destiny. That can't be the way that we do things, and it's not typically the way we do things. Destiny tried to interject in that proceeding. She was told to be quiet. She wasn't allowed to speak. That can't be the way that we do things. Her attorney never even checked with her when she said, I have a question. He just said, don't worry about it, and then agreed to this order on her behalf that would never let her see her children again. Your Honor, it's counsel's job not to get children back. It's not to protect children from abuse and neglect. It is counsel's job to protect the client's right to a fair process. And these attorneys failed to do that.
Is the 60B process a fair process?
Not as it sits currently, Your Honor.
Why?
It produces the timeline on which MP states, right, the 21 days beyond the appeal period is not enough time for any attorney to...
But unlike in a criminal case, we do have a whole nother issue, okay? We do have the permanency of children that we need to keep, and the best interest of these children, that we need to keep an eye on that ball, don't we?
We absolutely do, Your Honor, and I'm not saying that the 60B process has to be thrown out the window altogether. The affidavit requirement can't stay. The attorney writing the motion for 60B6 can proffer all of the information that the court needs to know without producing affidavits. The attorneys cannot compel those affidavits, and people have no reason to respond to those phone calls, especially not in a timely way. We have to be able to protect the parents' ability to bring those witnesses. Thank you.
Thank you, counsel. All right. Thank you, counsel, for hopefully the drive down from Bangor wasn't too bad. I don't know. And from out in the western mountains. For the argument today, and as is our usual practice, we will be taking this matter under advisement and issuing a written decision in due course. I also understand, Ms. Kilgore, that this is your first law court argument, and as a result, we would ask counsel to come back and take the greetings of the court, as is our usual practice. And